28, madam.
28.
Personal difficulties, madam. Can it be after 2 weeks? I've informed our
On the prayer of Mr. Deepang
No, that's not about that.
petition, list this matter after 2 weeks.
And my lord, item number 8, my lord, I'm sorry, my lord, there was some mistake when that postage did not come to us. Item number 8.
Yes,
Can it be taken up day after tomorrow?
that was
10, my lord, after 2 weeks. Then after 2 weeks.
after 2 weeks. Same.
8 is no?
My Lordship.
Yes.
Lordship, I beg to mention item number 30 on behalf of Diado. Here, conducting counsel Diado is out of station.
30.
Yes, Lordship.
Diado
Yes.
on the prayer of Mr. G. Thai, learned counsel, appearing for Mr. Diado, learned counsel to the petition. You are also here.
Yes.
Anyway, Mr. G. Thai, just delete. Mr. G. Thai, learned counsel for the petitioner. President, press for adjournment of the matter for another 2 weeks.
Yes, Lordship.
Praise the Lord, list after 2 weeks.
Deeply obliged.
May Lordship, I
Yes.
beg to mention item 11 and 12.
11, 12.
Yes. Due to some urgency, the arguing counsel is out of station.
Who is the arguing counsel?
Your Lordship,
Who is the arguing counsel?
Sunil Mao.
It was taken up yesterday also.
Yes, actually he was ready for yesterday, but due to some urgency, he went to his hometown this morning.
Can you go like that, just like that? Matter is fixed. On your consent, and then you just live like that. Yes, what is to be done? Have you read the brief?
I won't be able to assist the court because it's
There's nothing. You're an encroacher. You filed an application for allotment.
but
It has not been considered, that's all.
sir, it will, Your Lordship, it will be
We'll
injustice to the-
dismiss it, you vacate it, and then we'll direct it to make it clear that dismissal shall not be a bar to consider your case for allotment if it's in accordance with the rules.
Your Lordship, next date may be given, so the arguing counsel may make points because arguing counsel make points because it will be injustice to the petitioners. So
What injustice? We'll record everything, whatever you have pleaded.
maybe listed on Monday. That will be better because I got instructions, so it will be.
You have instruction to get it adjourned to Monday.
Yes, Your Lordship.
On the prayer of MS so-and-so, learned counsel appearing on behalf of Mr. S. Bo, learned counsel for the petitioner, 11-12, huh? List this matter on 03-09-2024. 3rd of September,
Yes, Your Lordship.
it is made clear that no further adjournment shall be granted on the next date. 3rd of September.
Yes, much obliged.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention one bail application. Bail application number 78/2024, Your Lordship, for listing
Next
on
week.
16, Your Lordship. For withdrawal only, Your Lordship,
Then we'll take it up today
today.
for withdrawal.
Your Lordship.
Today.
Much obliged.
Wait, please, my lord.
Yes.
Item number 7 also, my lord. Just a moment.
Yes. I have a doubt. I may not be able. Anyway, we'll see.
File our IA today
For what?
for impleadment.
Okay. You are impleading who?
I'm sorry, my lord, that costliness I have not.
No, this
Item number 7, Tumia Bogo versus Desha Bogo.
SAO,
SAO,
number one.
Listing evidence.
Today matter is listing for here,
Yes,
supplementary
seven
hearing
matter.
as a first item.
We're filing our
Substitute.
IA today for impeachment,
To whom?
for substituting the appellant. the
Okay.
first level.
Is
Yes, right.
is no more.
No,
Okay. Mr. Deepang, learned counsel for the appellate submits that during the pendency of the present appeal, the appellant has expired. Therefore, he prays for some time to file appropriate applications for substitution. Mr. Praise the Lord, list after 2 weeks,
IA we're filing today,
after a week, Mr.
after a week.
Tapak, learned counsel for the respondent is present.
May I, my lord?
Yes,
My lord, I beg to mention item number 27, my lord.
27.
Yes, my lord. I'm for the respondent, my lord.
27.
Yes, my lord.
Yes,
My lord, I've taken consent from the petitioner, my lord.
hmm.
And this matter, my lord, last order, my lord. Paper book was supposed to produce the court, my lord. Yet now paper book are not ready, my lord.
Paper book is ready. With records and paper books. Item 27.
Yes,
It's there. It's there. Paper.
no, my senior instructed me that it's not
You have
known
not
about.
received.
No, yes,
Mr.
Kimingi
Learned counsel appearing on behalf of
or Pada, my lord.
Mr. Opada, learned counsel for the learned counsel for the respondent
Yes, my lord.
submits that he is yet to receive the paper book.
Yes, my lord.
They are requested to furnish paper book to the learned counsel for the respondent during the course of within 2 days. Mr. List after a week.
Okay, my lord. Right.
My lord, I beg to mention item number one. In previous occasions, there was a communication gap with the conducting counsel, G. Majumdar sir. So any date may be given.
It's been listed for so many days, so many occasions. Yes,
This matter was pending since and the petitioners going to return within 6-7 months.
is there any surviving cause?
If there is a
Exist?
seniority loss, we claim the seniority loss. If the
What
seniority-
benefit, suppose if you granted the seniority, which you have prayed for, what benefit you will get?
Most of those, supposed to be on the basis of seniority loss, the promotion will be given. Promotion will be given, not it.
Oh,
Because it is instituted by my client process. Seniority will be given.
relax. You are on the verge of in the evening of your life. Relax. Why more promotions?
That's why what-
Initially, you were a doctor.
Yes. No,
Right.
no, this is a.
What more you want? Huh?
DMOs was it.
That's what I'm saying.
Yes, boss.
Now DMO.
Yes, boss. All are DMOs.
But you are a doctor.
Okay. Council on the way.
On the way. Who? Then we'll adjourn.
Yes, boss. Other also on the name of the port number 2, state council. Taking a port number 2. Port number 1.
Anyway. We'll see. Mr. Majumdar is not there. Is not available today.
Mr. Majumdar is here. What my learned friend, the appear is saying is that there was some communication gap in with Mr. Majumdar. So that is what he said.
We'll see then. For the time being. Possible for the time being. 1, 2, 3. Tell your senior, huh? We'll
Yes.
see. It's 2014 matter. Yes.
Yeah, please, my lord. My lord, this well application is filed in connection with Itanagar WPS case number 34/2024 under section 61 subclause 2 and 65 subclause 1 BNS Act 2023 and it is section 4 of POCSO Act. My lord, here in the case, before come to the brief fact of the case, I would like to read out the FIR, which is annexed in page number 11, my lord.
11.
And 11 is the original FIR and 12 is a type-out copy, my lord. May I read out?
Yes.
Subject FIR against one Keen by and his friend. I am to inform that on 1/7/2024 at around 9:45 p.m., my sister Miss A, age about 14 years, telephonically informed me she was sexually assaulted by one Keen by in one of the room of Sonam Hotel located in Gopur, Itanagar. She informed that she was invited to birthday treat by Sri Tacha Tade. Tacha Tade is one of the applicant here, madam. At Sonam Hotel, he was accompanied by two other friends, Sri Keen Bai and Tacha Ako. After a while, Tacha Ako and Tacha Tade went to call another friend of theirs. In their absence, my sister was raped by Keen Bai. This is the allegation, madam. So, rape was not done by this accused Tacha Tade and Tacha Ako, who is the applicant here in accused in the case item number 9 and 10, madam. That's arising of the same FIR. So both were arrested on 2/7/24, and now both accused are assigned in the judicial custody. And here in the case, 3 accused arrested, one Keen Bai, who is the prime accused in the case. So now both are in the judicial custody without any fault, my lord. On the day of incident, they were together, invited by the one Keen Bai for having some birthday party. And both were accompanied with Keen Bai at Sonam Hotel, Itanagar, Gopur. So after some time, Keen Bai has invited this victim girl, my lord. And after some time, victim girl came in the hotel and she was also accompanied with this accused person, and they have taken drinks together. And thereafter, this accused and the victim has asked them to leave the hotel. Accordingly, this Keen Ako, Tacha Ako and Tacha Tade, they both were left the hotel, Sonam Hotel. And after half an hour, again Keen Bai has asked them to come back at hotel. Already this victim was left from the hotel. So they both came back in the hotel and they again joined with the Keen Bai and they took drinks. And it was around 10:45 p.m. So all of a sudden the team of police came and in the hotel and they were arrested. That is the fact of the case, my lord. So these both accused never been commit the offense which is alleged in the FIR and never been commit the offense which is in fact in the POCSO Act, my lord. And allegation is only the convenient conspiracies. These both accused as having knowledge of sexual assault of the victim by co-accused one Keen Bai, my lord. So this both accused is very much innocent in the case. And accordingly, my lord, both accused were filed bail application before Honorable Session Court, the UPA, and the bail was rejected on the bail application was not considered, my lord. It was rejected on 7/8/24 on ground that this accused as having conspiracies for committing of the offense. That was the allegation, my lord. So my prayer is that Lordship may call case diary and item number 10 is, my lord, same arising of same FIR. Accused Tacha Tade is having
Okay,
some
listed
mental.
for the first time.
It is listed for the.
Okay.
Yes.
I thought we'll dispose of the matter.
Yes, your lordship may also issue notice to the informant, your lordship.
Okay. I thought I'll dispose of the matter.
And my lord, one of the accused having health problems, serious health issues. He was got accident in the month of January 2024 at Sepa, and he
Which
was
one?
item number 10, my lord.
We'll pass that. Not Mr. N. Rama. N. Rama,
Yes.
learned counsel for the applicant. Next, Mira. This is an application under section 483 of BNSS 2023. Bring for grant of bail to the accused person Sri Tacha Ako. Tacha Ako,
Yes, madam. Right, Chak.
in connection with Itanova WPS case number 34 of 2024
24.
under section 67, page 1 and 2, you see her. 67 within bracket 2, 65 within bracket 2, 65 within bracket 1 of BNS. Read with section 4 of POCSO Act. Come on, who has been arrested on 07 September
27,
07
24.
02 07
Yes,
2024. Call for the case diary.
Yes.
Scan copy of the case diary.
Scan.
MST Janet Learned additional PT appears for the state. The learned counsel for the petitioner to take steps for service of notice upon respondent number 2. Today, during the course of the day,
Yes, madam. Sorry?
steps during the course of the day.
Yes, madam. My lord, in regard to the steps of the private respondent number 2, who is the complainant or the complainant of the case.
Complaint in
So
either
that
complainant or the victim.
It's the informant, your lordship, since a victim is a minor, your lordship, the
So
informant,
informant.
So my lord, that step, sometimes we used to provide service before them and denied to receive the notice. of-
Then you bring that file an application if he refuse to accept.
So
File an affidavit if they refuse to accept.
my lord,
Right.
my prayer is that if the honorable court may direct.
No, it's
For registry.
your
informant
lordship,
only.
your lordship, if the service is through the normal process, your lordship, there is no question of not accepting or not, your lordship.
Yes,
The-
during the course of the day.
Hello.
Take steps.
the-
Same name will be different, right? A list on
On 23rd, your lordship, 20
On 20, my lord.
23rd, your lordship.
23rd. 23rd.
23rd.
List on
Friday.
23rd. 08/2020.
Deeply, your lordship.
Much.
Same, but you add
Yes.
that it is submitted by the learned counsel for the applicant that the accused
Ac-
is suffering from serious.
Yes, my lord, item number 10, accused Tachata, he was.
Yes, in item
yes,
number 10,
got
not in 9, item
accident,
suffering from serious.
serious injury on his brain, and he was took operation in the GNRC
Anyway,
Guwahati.
he's suffering from serious illness. Come on. The appropriate medical treatment appropriate medical treatment may be directed to be. And appropriate medical treatment be taken for the accused. This the appropriate medical treatment to the accused. Yeah, you want that medical treatment.
Yes, my lord, my prayer would be the interim bail may be granted, supposed to
No, it's not possible. It's POCSO.
yes, my lord, that is, but doctor has directed to
I've said
recheck. Re-checkup after 4 months. Now it's going on, it's 4 months is going on, man.
anyway, appropriate medical treatment be given to the accused. Mr. The having considered the submission come up, the jail authority shall ensure that the proper medical treatment is given to the
Yes, madam.
accused. If no, ensure that the proper medical treatment is given to the accused if is actually suffering from suffering from any illness.
Deeply.
And then CD will be there in that case. If
CD
if he is suffering
Yes, yes. If there any application has
illness and all,
any application has been if any application has been made to the jail authority, that might have been
he
taken into
make an
consideration.
application.
Yes.
If he is really suffering from serious illness, even if he is in judicial custody,
Yes.
treatment can be
Yes.
given to him. You make an application
Yes.
immediately.
Deeply.
MashaAllah.
Number 1 and 2, 3.
Well, this is an
Sara
old
Sahab.
case,
Ah,
but somehow my clients, they made a last minute contact with me.
okay.
They have requested me to proceed with
the-
argument on merit.
But what benefit you will get?
Well,
Suppose if your writ petition is allowed.
they will get the pensionary benefit of IRSK.
No, seniority you will not get. On seniority, do you get pensionary benefit?
Yes, yes.
Under
Sir,
which law?
According to their version, I cannot
We can understand that if you are pro in this writ petition, you may ask for some promotion, national, whatever,
That's why that financial benefit would be there.
national on all those for promotion. But just because you are senior, you will not get there unless
No, on the basis of seniority, there will be no financial benefit or per se
and
even any
your
consequence.
junior Mr. Bam has told me that has already stated that he will be retiring within 6 to 7 months.
Correct, Miller. Some seven.
Enjoy the evening of your life.
That is the reason why.
Enjoy the evening of life. You have enough.
No, well,
You have served the people of the state enough.
that's fine.
Must be
Miller.
around for 30 to 40, 35 to 40 years. At least 30 years.
No,
Nearly 30 years.
no, that 30 years, sometimes I feel that
Because you are retiring at the age of 62.
62 years. Miller. So therefore, sometimes when these kind of things come up, it is always prudent to think that unlimited desire of human being
Of course, it depends on person to person.
is a necessity.
For
even-
me, 65, 62, finish. What more you want? Let the next generation to fill up the gap, which vacuum which you have created. You go for that. You advise your client.
Yeah. But since I'm handicapped and they made a last minute approach to me,
No, it's your duty to you
Sir,
can
please,
advise your client.
even I advised them, but they said, sir, please go on marriage.
It's 2014 matter. You would not like to
And
adjourn.
this was filed during my brother
Will
Kento's
not-
period.
Huh?
This was filed during my brother Kento's period.
Yes.
And all down the line, 10 years. And they were seeking adjournment after adjournment, I don't know. Otherwise,
Mr. Panging, no, you are not appearing.
No, I am there, item number 2, but this decision depends on the outcome of item number 1.
So you will not make any argument.
It will depend on what your lordship decides. Well, issue is very simple in this case, Manoj. He was appointed in the GDMO cadre. Then again,
Where is Mr. Majumdar? He's not ready.
Yes, yes,
He's
sir.
not ready.
Yes.
Next week.
next week.
When do you want?
Yes,
Find out
Next
the date.
week.
yes,
Where is
immediately.
your schedule? नहीं है ना?
So, Mr. Titi Tara and Mr. D. Pangi, learned counsel for the petitioners
Next week you see.
in both the writ petitions are ready for argument of the matter. Come on. It is submitted by Mr.
Endoji.
N. Doji.
On behalf of D. Majumdar.
learned counsel appearing on behalf of Mr. D. Majumdar,
Yes.
learned senior counsel for respondents. That the senior counsel, what is the ground?
28.
What is the ground of adjournment?
Uh, in previous occasions, there was communication gap with the conducting council.
D. Majumdar could not be senior counsel, Mr. D. Majumdar, senior counsel could not be briefed due to inadvertent mistake on the part of the assisting counsel. Therefore, he praised that the matter may be listed after a week.
22nd.
Next
Second,
para.
23rd.
Considering the
23rd.
matter
23rd.
is matters are pending since 2014. Come on. The prayer for adjournment is granted as a last chance.
Huh?
Mr.
27 को तो lower court में ना, 28.
Let the matter be listed on 22/08/2024.
28.
Mr. It is made clear that no further adjournment shall be granted on the next date.
Yes.
28.
Must supplies.
28.
20,
20.
20,
28.
28
28.
or 22.
Yes.
28,
Yes.
28, make it 28.
Oblige.
Must supplies.
Mail also.
Yes.
Note of this, the land dispute process, there is two place level cover L process. One is in favor of petitioner and one is in favor of respondent. Notice the impugn order lawsuit, which here in this case lawsuit challenge lawsuit is annexure 9 lawsuit.
Election 9.
Yes,
Page.
page 49 lawsuit. Land disputes lawsuit is land is a called car is a lawsuit. But it may be lawsuit.
Yes.
The Talar Taji appellant along with his counsel P. Nima presents and also respondent Padam Taji. The counsel for the appellant submitted that this instant case dispute is approximately 1 acres more.
So on ground you are challenging it.
Yes, Lordship, I am challenging Lordship. No opportunity was given Lordship.
Then whatever this Talar Taji, appellant
Lordship.
along with his
Yes.
counsel, present and also
Talar Taji,
respond Sri
yes,
Tadam Taji.
There is only Lordship notice is issued. Lordship. Notice only issued Lordship.
Along
And
with
we appear Lordship.
you are Mr.
Mr. Tadam Taji Lordship.
and also the respondent Sri Tadam Taji.
Yep.
Then what
Then-
does it mean?
Miss Lordship, we present on the death day Lordship. We appear Lordship.
Then
But we are not given opportunity to post or test of cross examination Lordship.
what is the requirement?
Lordship, requirement Lordship, if Lordship,
What is the requirement?
Lordship, if Lordship, we
It's
have to
before
at
the
least-
additional deputy commissioner.
Yes, Lordship,
It's an appeal.
appeal Lordship.
So by this order,
At
what,
least
what,
Lordship,
what,
hearing should be done Lordship. At least Lordship, hearing should be done Lordship.
yes, is it so? No hearing.
Kindly come to page 50, the immediate next page. my
Hmm.
lord. The respondent has submitted it.
Where
It is not that down below, it is page 50. They have been given
After
opportunity.
hearing in a nutshell manner,
Yes,
No,
This is
no,
only
my lord, the
Respondent
respondent
submitted
has,
land in dispute, it belongs to him and the kebang held on so and so by the village authority in my favor, accordingly prayed to appeal the decision of said kebang. Huh? Yes.
This.
hearing opportunity it was given.
Huh?
Hearing opportunity, my lord, it was given.
Hearing opportunity, Lordship.
But after hearing in a nutshell manner, how the appellate court go for a nutshell manner? Let's just read the last para.
My lord.
Hmm.
And also examine the case records, my lord.
No, after hearing,
Ha,
page 50, last para.
my lord. After hearing in nutshell manner from both the parties and also
How
examine
can you
the,
have a nutshell manner?
my lord, the language ADC, we can understand that much.
Yes, this Kebang decision of 9/2/2080,
80, Lordship. We contradict.
so your father has put his signature
Yes, we contradict it, Lordship.
and did not raise any, what does it mean? Raise any objection to the thorough result and distribution of the Kebang held on 01/10/2018.
It's 2018 cover, Lordship, in between the zone of the respondent number, two zone of the private respondent, Lordship.
Yes.
That is, Lordship, distribution of property in between the zone of the.
How you are related?
We are the family, Lordship. We are the family, Lordship.
Go back, settle it.
Lordship, at least, Lordship, if this order is not interfered, Lordship, the settlement is not possible, Lordship. And Lordship, in this Lordship, 90.
You are family, but how closely related?
Closely related, Lordship, as per order,
How
Lordship.
close you are? How close you are with each other?
Chattel,
I mean the
Lordship,
relation.
two generations, Lordship, two generations. Our forefathers supposed to say.
It's an ancestral
Yes,
property.
yes, ancestral property, Lordship.
But facts remain that your father has put a signature.
Lordship, that is, Lordship, we contradict it, Lordship.
You cannot
That is not,
contradict now.
Opportunity.
Have you
Lordship.
challenged? Have you challenged
that-
this 9/2/1980?
Yes, we not challenge, Lordship.
Then-
We only know this Gaba order, existing of this Gaba order, when this appeal was filed.
Yes, have some
In two Gaba, Lordship.
have some respect to your forefathers also.
No, Lordship, that Gaba is, Lordship, that Gaba is purported one, Lordship, supposed to be purported one. If we see the signatures of the Gaba member, Lordship, which is not matched at all, Lordship. Yeah, Lordship, I saw, Lordship, from the record, Lordship.
Why not going to appreciate the evidence and revisional
Yes,
jurisdiction?
for Lordship.
On the face of it, you have been given an opportunity.
Opportunity, Lordship, opportunity, at least, Lordship, when the government, chairman, Lordship, at least to be there, Lordship, in this case. No Gaba.
It's an appeal.
Yes, Lordship. Appeal, Lordship. At least have to hear, Lordship. Only one day, Lordship.
To whom?
Only one day this whole process.
No, you have been heard. You have made your argument. You have made your submission.
No, no, Lordship.
It's
Only one
record.
paragraph, Lordship.
It's
I want-
doesn't matter.
My statement is recorded only one paragraph.
So it's enough.
So,
You are saying the opportunity was not given.
yes, Lordship, cross examination, at least for documentation, Lordship, I have to give it, Lordship, so that I can.
Yes.
Got this.
Why no opportunity? Why not
Opportunity.
sell? Why not sell?
Opportunity, my lord, it was given.
But
Therefore,
why
it
not
is-
sell?
This language nutshell.
Ample opportunity should be given. Why not sell?
Otherwise also, my lord, if the
But
earlier.
send it back. Fight it out again. But then doesn't have a jurisdiction now. ADC doesn't have a jurisdiction now.
Civil
Should be
judge,
before
civil judge.
Civil judge.
Civil seniority.
You are correct, he has been given, but the order itself says nutshell manner.
That's a better.
How can you have a
Otherwise, my lord, other than that, because they have invoked 227.
Huh?
They have invoked 227.
Yeah.
Supervisory jurisdiction.
Yeah.
So there are no any error or any inherent defect in any other manner, like assuming the wrong jurisdiction or exercise of wrong jurisdiction. But their limited issue is that they have not been given opportunity. But order it says opportunity it was given. Anyway, my lord, in that case, I do give consent, my lord. Matter may be interfered with, and then matter may be remanded to the civil judge junior division, Dapur region, for fairness of everything, because so many disputed questions for me also. What I am looking at into this petition, and then other affidavits we have filed. And it's very difficult also to settle the decision of village level, my lord.
Second period is also said. You have said this thing was not heard. Also heard from village authority, city so and so and so and so who conducted the case.
No, also here is the case also Girik River is not the government of 2021 government, which is in my favor.
So apart from opportunity of hearing, what other grounds are there?
Lordship, here Lordship, we contradict the 1980 judgments is not in favor of it. Is purported one.
Huh?
We claim that this is purported one.
What purported? What do you mean by purported one?
That means Lordship, it's not an legal valid one.
So we call it purported one.
And they are challenge Lordship.
You have not challenged the 1980 Gaba.
Yes, why not challenge?
Then how you can question now?
Lordship, that only Lordship, yes, we came to know Lordship, during the proceeding of after obtain the applications, every application from the ABC only. This is come to knowledge.
So since he is giving you a concession, otherwise you have to dismiss this. Remanding back. Not remanding will give an liberty to approach the appropriate forum in accordance with the law. Including if you want to file anything, it will be taken care. Including the delay. Will not comment on it. Will approach us, you.
I have to approach, my lord. I feel I have that. So those period may be
You file
kindly
an application. Will not say anything on this.
My lord, those delay period may be
No, we cannot. They will consider.
at least
You
quickly.
have filed the appeal within time at that point.
Yes.
It's a good ground. Huh? You would not have given concession, otherwise I would have been dismissed.
Because for me also, like, there are so many disputed questions, of course.
No, the ADC has relied on the Keba decision of 1980
1918.
and some 2018 when there was the distribution of property.
Property among two sons.
He has not raised any question.
Now they are saying that property is not the present one.
Okay.
That is the case.
Okay, heard Mr. Jibam, learned counsel for the petitioner, and also heard Mr. K. Tama, learned counsel for the respondent, sole respondent.
Sole respondent, my lord.
By filing this revision petition, the petitioner has put to challenge the order dated 11/04/2022 passed by the Additional Deputy Commissioner, the Upper Subansiri District. Whereby the appeal of the respondent has been allowed. And allowed thereby has held that the disputed land of Tari Reserve area belongs to the respondent and the petitioner. Here has no right, title, interest and ownership over the land. Please stop. Next paragraph. The yes. The facts of the case is projected in the present present petition is that a dispute had arisen between the petitioner and the respondent in respect of Tari Reserve, TARRIJ, land list of the dispute was settled on 09/02/1980. Is there any other? Mr. No, delete that, huh? The parties are related to each other as the descendant of same forefathers. Mr. You have filed the, what is the last Keba? 01/10/2018. Against which Keba you have filed an appeal?
Yes, Lordship,
23,
I'm 19.
23,
Huh?
That one in 2021.
23 February 2021, my lord.
Where it is?
It is, my lord, in their petition.
In my petition, Lordship, in Excerpt 7, Lordship.
23 February 2021.
Annexure 7.
7, 41. File on 4/3/2021.
Page
Page 41, Lordship.
This,
Your rating.
in your petition, 23 February 2021, the decision of village authority.
Oh.
Annexure
annexures, village authority lordship, annexures lordship, 6 lordship in my favor lordship. 23 to 2021 lordship. Annexure
Page,
6 lordship. Page 47 lordship. Type copy lordship at 39 lordship. Transmission copy.
7.
Page 39. Type copy.
Hmm?
Page 39.
39.
Type copy. 39.
Hmm. Against this, you have filed that.
Yes. Against this, immediately we have filed appeal on 4/3/2021. That is at page 41 in their
Next
Uh,
one. A KEBA was conducted on when? 23rd, 02 2021. 21, right?
21 lordship.
Regarding the above dispute between the petitioner and the respondent, wherein the KEBA has decided that the respondent shall no. It is held that since the petitioner has paid rupees 20,000 as a compensation to the respondent for planting of orange trees, there would not be any dispute with respect to the land in question owned by the petitioner. Mr.
my lord, this amount we have not received.
Huh?
This amount we have not received so far.
Anyway,
Huh.
Mr. In other words, the dispute was settled in favor of the present petitioner, Mr. Being agreed, the respondent has filed an appeal. Where is that appeal?
Page 41.
41.
41.
Appeal before the appeal under section 40 of the 46 of the Assam Frontier within bracket Administration of Justice Regulation 1945 before the Additional Deputy Commissioner, Upper Subaltern District.
And it was filed on, my lord, 4/3/2021. Kindly that may be reflected.
On 4/3/2023.
2021, my lord. 21, my lord.
21. 4/3/2021. Please stop. After next paragraph, the Additional Deputy Commissioner by order dated by the interim order dated 11/06/2022 has disposed of the appeal of the
11/4.
respondent.
11/4.
11/04/2020. And held that this land in dispute dash Tararijo land, Tararijo land, Tararijo area, belongs to the petitioner, respondent. And the petitioner has no right and title over the said land as the father of the petitioner has put his signature, subscribed his signature to the Keba decision dated 09/02/1980, and the petitioner had raised no objection to the terrorism land distribution. Keba dated 01/10/2018. Next one, Mr. G. Land Council for the petition submits that the impugned order dated so and so 11/04/2022 has been passed without hearing the petitioner, which violates the cardinal principle of natural justice. I.e., opportunity of hearing. He submits that since the appellate authority, no, not since, he submits that the Keba decision 09/02/1980, on which the appellate authority has based its decision, has no legal validity, as the petitioner has raised an objection to the said Keba decision. He further submits that the so-called land distribution Keba of Tarirejo area held on 01/10/2018 is a different area, public plot, where the petitioner has no connection with the said land. The land in question is a different area. Therefore, the apart from not therefore, Mr. He further submits that if the appellate authority sees grounds of doubt of the Keba decision, the matter should be matter ought to have been tried afresh by giving an opportunity to the parties, including a chance to adduce evidence. Therefore, he submits that apart from not providing any opportunity of hearing, the appellate authority has violated the provisions of the Act of provisions of the law, and as such, he prays for setting aside of the impugned order that is so and so 11/4/2020. Next. Mr. K. Tama, Land Council for the respondent. On the other hand, submits that the petitioner was given an petitioner was heard as reflected in the records as well as the as well as the impugn order itself. Mr. Therefore, there is no question of not giving any opportunity of hearing. Mr. So far as the merit of the matter is concerned, Mr. K. Tama, learned counsel, clearly submits that it indeed involves a disputed question of facts which requires a proper trial by allowing the parties to adduce their respective evidences. Next paragraph. I have heard the learned counsel for the parties' rights, sir. You said he was heard, but then
Pardon, my lord.
there involves a disputed question of facts. So
My
it
lord.
needs to be properly tried.
My
That's
lord,
all.
for fairness of everything for both parties.
Next one. I've had the learned counsel for the parties' rights, and there is the materials available on the record. The record is only to show that whether you have been heard or not. You were heard. Anyway, next paragraph. On consideration of the records, the materials, including the perusal of the records as well as including the impugn order dated 11/04/2020 passed by Additional Deputy Commissioner. It clearly reflects that the petitioner was heard and he had made a submission to the effect that the land in dispute belongs to him, and the Kebang held on 23/02/2021, where the village authority is in his favor, and he has prayed for affirming of the same, affirming of the said Kebang decision. It is also reflected that some of the village authorities who have conducted the Kebang with respect to the present disputed land were also heard. Mr. Next paragraph. It is noticed that the Additional Deputy Commissioner, appellate authority, has also recorded that the appeal was heard in a nutshell manner. Mr. Law requests that if the appellate authority sees ground sees ground of doubt of the Kebang decision, he shall set aside the Kebang decision and try the case de novo. However, admittedly, the appellate authority appears to have failed to appear has failed to apply the provisions applicable in this provisions of the law. Next paragraph. On the issue of not providing any opportunity, I'm of the view that having peruse the records. Come on. I'm not inclined to accept this same as the submission of the learned counsel for the petitioner is contrary to the records. As he was heard and he has made this, as the petitioner was heard and he had made his submission before the appellate authority. However, having considered that the appellate authority has not applied the requirements, has not followed the requirements of the provisions of law in the present case. Come on. I am of the view that the impugn order would not be, is not, it would not be allowed, to be sustained. Since as it clearly reflects from the impugn order as well as the impugn order that the matter was taken up. The matter was taken up in a summary manner. Having considered that the issues, the disputes between the parties needs to be determined by giving the parties an opportunity to adduce their evidences. I'm of the view that the parties be relegated to the appropriate forum for its proper determination and adjudication of the dispute in accordance with law. Having considered the above, though this code is not, though the learned counsel for the submission of learned counsel for the petitioner of not giving an opportunity to in a summary manner, is not acceptable. In the interest of justice and the fairness, I'm of the view that the matters, the disputes between the petitioner and respondents requires to be determined by a proper trial, by a trial before the appropriate jurisdictional civil court. Accordingly, the impugn order dated 11/4/2022 passed by the Additional Deputy Commissioner, Dumpo Region, Upper Subansiri District, in the case number DMJ/LK-01/2019, page, what is this page?
Page 49. Page 49.
49. Dated 11/04/2022 is hereby interfered with and set aside. The parties the liberty is provided
My
to the parties to approach the appropriate jurisdictional civil court for proper determination, for fair determination of the dispute between the petitioner and respondent. Obviously, he will not file.
He will not file. We will be filing.
We'll say, not you just.
As per my lord, amendment of Civil Code Act 2022.
Next para. Liberty is granted to the respondent herein, namely so and so. The respondent herein to approach the appropriate jurisdictional civil court. Will it be an appeal
Or appellate court.
for against the Keba decision so and so in accordance with law?
Well,
No, as per the provisions, applicable provisions, list of next para. It is made clear that the civil
Time.
court, whether appellate or original, shall condone the delay in filing the, in approaching the, in filing the appeal or appeal of the petition in view of the fact that the respondent has filed the appeal against the Keba decision on within time.
4th March 2021. That is within time.
And the present revision petition has taken a considerable time before the High Court, before this court,
Well,
for its final consideration and disposal. The revision petition is disposed of.
file your response.
We understood. Make it properly. Any news
No, I
Any
have
information?
absolutely no.
next week?
My lord,
Can we try?
your lordship, since your lordship is not taking up for consideration because your lordship is deferred with the finding of Justice Above.
Yes.
My lord, observed that this may be listed before any other bench, that way we can discuss. We don't know how long it will take, the reference.
Should have been considered by Monday or Tuesday. I don't. Have you inquired?
No. It takes too long now, there would be quite unclear of the. So if your lordship may observe, that since your lordship by the order says referred to the earlier finding. So this may be better for any other bench of your lordship. Then, because the power is inherent in the lordships, either under the CRPC or the PNS.
Heard Mr. Deepang Lal, counsel for the applicant, and also heard Mr. T. Lal, additional PP for the state. In view of the order passed by this court, in view of the order passed by this court on when? 8/08/08/2024, in a related applications for which wherein this court has respectfully deferred with the order of the coordinate bench dated so and so. You just keep it,
Yes.
dated so and so. Order of the coordinate bench, dated so and so in BA bail
AB
application,
102.
AB 102 of 2024. Comma. List this matter before any other appropriate bench.
Lordship dated 19/7/24.
19/07/2020.
Okay. Don't
Obliged.
make a mistake. You get the exact same order. Which folder? 6. 6. No, this is different.
Lord,
This is new act,
all right. Yes, it's new.
another new act.
Yes.
Yes,
Yes, as per this WT message, he is already under custody, Lordship.
under
Yes.
custody.
Yes, it's on 8/8.
Why so in a hurry? Same day.
Yes, my lord.
Before that only, before you filed the bail application
7.
on 08.
Yes, 08 evening time. Accused applicant appeared personally before the IO and surrendered himself.
You have surrendered.
Yes, my lord.
You have filed the bail application on 7th.
Yes, my lord.
It was taken up on 8th.
Yes, it was on 8.
On 8th, you were already arrested.
8
Okay,
evening.
16:30, 4:30 in the evening.
Yes.
On your
Yes, in the evening time.
surrender.
Yes. Matter is infectious.
It's infectious. Lordship.
I'm sorry. These are the things.
Yes, my lord.
Basically, better install POXO.
Yes, my lord.
That's the reason.
Yes.
I'm sorry.
Yes. Yes.
Heard Mr. G. Lowland, London Council for the applicant. Accused applicant, please stop. MS. L. Hage, London additional PP. By placing the copy of the WT message submits that the accused applicant has already been arrested on 08/08/2024 at 4:30 at 16:30 hours. Yes. Next minute. In view of the above, the bail application, this anticipated pre-arrest bail application has become in process. Accordingly, same instance closed
Yes.
and disposed of.
Obliged, Lordship.
Yes, sir. What is this?
This is the first appeal. RSF.
Any, have
Yes,
you filed affidavit?
service. Yes, Manoj, and the notice upon the respondent has been completed, Manoj.
Where,
9/1/2024.
has it been recorded?
Yes, Manoj. 9/1/24. By your lordship only.
Has it been taken on record?
Yes,
right?
Manoj.
Okay.
Yes,
Then
9/1/24.
will, what is to be done?
Manoj, this matter may be disposed of, Manoj,
How?
by remanding back the
Listen.
matter. Yes,
Huh?
by remanding back the matter.
We'll give them a chance, one more
Hello.
chance.
Many chance has been given. After this 9/1/24, many orders.
One more chance, last chance. You can send appeal.
Yes.
You just can, of course, we understand. Your anxiety, we understand.
Manoj.
But let us give one more chance.
Manoj, this is a very simple issue, Manoj.
Maybe.
Mixed question of fact and law, Manoj, cannot be decided.
Okay.
Manoj, second last order, Manoj, there was a chance given, Manoj, by Justice Kosik.
One more chance. Next week.
Manoj.
Do you have any? You cannot.
Manoj,
Can you inform? No.
inform, Manoj, we have some completion certificate, my lord, I have annexed, my lord.
Hmm.
And my lord, may kindly come to page number,
Completion certificate I
Yes.
have seen.
yes,
And the details work
Ye-
of the
yes. Now,
being counter.
my lord, these material are supplied for the erection, my lord.
Yeah.
After the supply of these material, only erection.
No, I'm asking what is FNI?
That, my lord, I do not have idea. my lord. Only the thing is that, my lord, supplied, my lord, is shown.
So
to be-
according to you, by this document,
Yes, my lord.
it clearly shows that you have supplied.
Yes, my lord.
It says and actually supplied and erected in the field under Sobagya.
Yes, my lord. This is
one item.
this is one
What
item.
about the rest?
Then another item, my lord, on this in the same page, my lord, a serial number 11 and 12, my lord. That, my lord, we'll have to compare with
Oil earthing for false aluminum paints.
another, my
646.
my lord.
There's a difference. Page 26.
Page 26, my lord.
Oil earthing for false. Quantity 288. This is 644.
My lord is referring to which page, my lord? Page number 26, my lord.
Serial number 10.
Yes, my lord. This is 626.
Uh,
This is supplied, my lord. And aluminum paid 906, my lord, liters, my lord. And this is one of the supplies, my lord, I have supplied to the department, my lord. And my lord, now come to next.
just wait there.
This is
Copper plate earthing. 644. Aluminum paints.
now, my lord, let us this is clear one by one, my lord. Because I have, lord, MS guard bracket, my lord. According to the document, my lord, maintained by the department, my lord, I have supplied only this item, my lord.
Yes.
It is 323, my lord.
Yes.
Now, my lord, let us
Serial number 10.
no, my lord.
Copper earthing.
Now let us come
Copper
to
earthing. First copper earthing.
serial number 10.
10.
10, my lord. It has also been fully supplied, my lord. That I will.
Just see. Quantity 646.
Yes.
And come back to page 29 of the affidavit.
Now
it is
Now, my lord, that is why, my lord, let us come to page number 36, my lord. For copper, calculating this copper plate, my lord. Page number 36 first, my lord. Page number 36.
Aluminum paint 3956 liters.
Page number
This is
36.
6906.
Page number 36, my lord, may kindly turn to page number 36, my lord.
Yes.
Copper arting plate of size so and so, my lord.
Hmm.
Supply rates, then, my lord, the quantity supply is to
2452.
plus, my lord, again, page number 40, my lord. Here, the quantity supply is 2, my lord. The rest,
This is-
remaining,
It doesn't tell you. Page 34, you see, quantity is something and 29 of affidavit. There's a difference in quantity.
no, my lord, may kindly come to page number 36.
Sir, this is the reason that read court cannot.
My lord, this is the document, my lord. Let me submit, my lord. Page number 36, I have supplied two quantities set
It
of,
appears that you have supplied something.
no, I have wholly supplied, my lord.
Suppose you have been given the order. You have supplied some 6, 7. That is what they are saying.
My lord, this
What
is,
that indicates. See, page 34. It's okay. MS guard brackets 323.
page 20.
It's silly.
Yes.
Then so copper plate earthing that is 288. But in page 34, it's something different. Serial number, there's a difference in the quantity.
My lord, I have,
And the aluminum paint 3956 liters. And it shows something different.
my lord,
So it's
allow me to submit, my lord. I will text, my lord, to.
this is
my
the
lord,
reason we cannot interfere. We cannot entertain such a disputed thing.
my lord, my lord, if the figure given in this abstract, my lord, it is correct, then, my lord, it has to be presumed that I have wholly supplied, my lord. In this abstract, my lord, I have to.
It's not assume and presume. It's,
No,
it's a clear cut, the undisputed.
Yes, my lord, this is undisputed. This is their document, my lord. From their document only, my lord, I am trying to convince you, your
See-
lordship, that I have wholly supplied the material, my lord.
How?
Now, my lord, I have seen page number 36, my lord.
Yes.
In page number 36, my lord, I have supplied 2 units of 2 units. Yes,
What 2 units?
arting, copper arting plate, my lord.
Quantity.
Yes,
2.
my lord.
Ah.
Page number 32. I have supplied 2 units. Now again, my lord, come to page number 30, my lord. 30. Here I have supplied 6 units. Sorry, page number 40. I have supplied 6 set, my lord. Page number 40, my lord, may kindly come to page number 40. Six unit, my lord, is page number 3, my lord. From top, my lord, 1, 2, 3, 4, 5. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11.
Yes.
My lord, can see 6 unit I have supplied, my lord.
So
I'll sum up, my lord, in the last, my lord. Now again, my lord. Now come to page number 44, my lord. I have supplied 72 sets, my lord. Page number, my lord, may kindly come to page number 44 again. I have supplied 72 sets, my lord. I'll sum up in the last, my lord. And at page
obviously
number,
you will sum up at the last only. How you can sum
at
up?
page number 48, my lord.
Ah.
My lord, may kindly turn to page number 48, my lord.
Yes.
Here I have supplied 208 sets, my lord.
Yes.
Page number 48, my lord.
Yes.
208, my lord. I have supplied, my lord. Then, and on summing up, my lord, this comes to 288, my lord. Now, come to the dear affidavit, my lord. Short supply they have shown for this item is 288. And this document, my lord, which I have obtained from them, my lord. This shows the total 2 plus 40, 40 plus 44 plus 48, my lord. That is 288 sets, my lord.
Yes.
That I have supplied, my lord.
That is copper plate earthing. Then
Now,
rest
we have done with, my lord, two items, my lord. Now,
deep-
next
deep-
item, my lord.
deep orange pen.
Yes, deep orange paint, my lord. Quoted, my lord. May I again, my lord, take to page number 24, my lord. Page number 24, my lord.
Likewise,
Likewise.
according to you,
Yes, my lord. Like,
you have supplied
yes. And
from their own documents.
yeah, from here on.
You have obtained it from RTI
Not,
because some of them are typed copy.
yes, because my lord,
Typed by you only.
but then, my lord, is the seal and sign of the department, my lord. And they have not this disputed this fact in their affidavit, my lord.
Yes.
Now, my lord.
So according to by relying on these documents,
Yes.
though they have said that you have not, you have sort supplied these items, it indicates that you have supplied
I have supplied. That is why, my lord.
in terms of quantity and the quality.
Yes, that is why, my lord. After all this material is supplied, my lord. What is the importance of, my lord, this completion certificate, my lord? They
Yes.
are not disputing that they have issued this completion certificate, my lord.
Yes,
It cannot be randomly issued, my
that is
lord.
your answer.
It cannot be randomly
Okay.
issued, my lord.
Will
So
hear-
therefore, my lord, therefore, my lord, basing on work done by me, my lord, they have even sent for this release of the fund, my lord, to the chief engineer, my lord. And chief engineer has already sanctioned the fund for further disbursement to the petitioner, my lord. So since there is no dispute, my lord, as I have submitted earlier also in
There is a dispute.
Therefore, my lord, these are not a dispute. This is extensive evidence, my lord. In such a cases, my lord, I will just place judgment. Exceptional circumstances. The High Court would be justified in exercising such a power to the exclusion of other available remedies only when it finds that the action of the state or its instrumentality is arbitrary and unreasonable, and as such violative of Article 14 of the Constitution of India. In any case, in the present case, we find that there are hardly any disputed question of facts. It is undisputed that the appellant was the highest bidder for the sand block in question. The appellant has deposited an amount of rupees so and so. The Panchnama prepared by the circle officer, Kale respondent number 5 clearly exhibit that neither possession of the sand block in the question was given to the appellant, no excavation of sand was done from the said sand block. The said position is reiterated by the passenger, current respondent so and so. report submitted to the collector respondent number 2, that is so and so. The sub-division officer, Farad so and so, in report so and so, addressed to the collector Sahara also confirm the said position. A paralegal of the letter that is so and so also does not dispute the said position. However, he directed his subordinates to submit original file of the appellant. Now that it appears that subsequently after the authorities requiring circle officers and so and the collector found that neither the possession of the sand block was handed over to the appellant, nor the excavation of sand from the said sand block was done. At the instance of the collector, the file for grant of refund was being processed. It further appears that the file in transit was misplaced, and on this ground, the appellant was denied the refund. It could thus be seen in this admitted facts that the denial on the part of the respondent to refund the amount to the appellant can by no stretch of imagination be called as reasonable. The action of the respondent in denying the refund of the amount of the appellant.
Yes, this was a case where the appellant was a highest bidder, and he deposited the entire amount
Yes,
of the auction.
Yes,
And the sand block was not given to him.
Yes.
He could not excavate it thereafter. He asked for a refund of the amount deposited by him for the auction.
Correct, my lord.
And in that case, on the basis of the finding, records and the materials on that, in that case,
Yes.
court held that it's not a dispute, it is
Correct.
undisputed.
Yes, correct, my lord. Therefore, my lord,
It's not a case of payment of outstanding bill.
whatever, my lord,
See.
on the
See, depositing an amount for an auction is his amount only, appellant amount. It's not how much he has deposited and how much. It was clear, entire amount was deposited for entire auction. It was fixed. It is his amount only.
yes, my lord.
But then he was not given the block, same block. Therefore, directed to refund, there is no dispute. Here is a case, you have claimed that you have supplied the materials and accordingly 70% has been paid. 30% they are saying that you have not supplied this amount, right?
Yes, ma'am.
And you are showing the documents has not been obtained through RTA also. Of course, maybe their records, but how you have procured it? It has to be legally procured, obtained, the documents which you are relying.
With regard to that, my lord, my submission would be that this is
Therefore,
this
Therefore,
affidavit,
they are disputing in a matter of non-payment of bill. Once there is a once they dispute, then court cannot.
this, my lord, to my humble understanding, my lord,
Especially the High Court.
only because, my lord, why,
You will have to go to the civil court.
my lord, on my humble understanding
Yes.
would be that, my lord.
It's okay. This is your submission. That's all. Any other?
Yes, my lord, this
This is enough for you.
that is enough, my
But
lord.
the Punahinda goes against you.
It goes, but principle, my lord, they have observed, made an observation, my lord.
It's there. But then it has to depend on case to case.
Now, my submission, my lord, would be that, my lord. Since, my lord,
No, I have submitted, I have accepted you, heard your submission. That's all.
then I will
Anything
become,
else?
my
Anything else?
reply, my lord.
What reply? Anyway,
My lord, page 21 is the agreement, my lord, the writ petition.
Hmm.
And in page 23, there is a clause
it's 21 of what?
of the writ petition.
21.
Yes, this is the agreement
Yes.
with the petitioner, my lord.
Hmm.
And page 23, my lord will see clause 4.0, settlement of disputes. It is specifically agreed by and between the that all differences or disputes arising out of the agreement or touching the subject matter of the agreement shall be decided by the process of settlement and arbitration as specified in so and so, so and so. Meaning thereby there is a provision for arbitration. My lord, here the entire case is that he has completed the work, my lord, and supplied the entire materials, my lord. We have raised a serious dispute that he has supplied only 70%. 30% he has not supplied. And to that effect, the executive engineer has also given him the intimation regarding short supply of materials, madam. And that was even prior to the filing of this writ petition, madam. 23/12/2022, madam. And that was also sent in our affidavit, madam, at page 29. That, my lord, I will not bother, my lord.
Yes.
Short supply, my lord, has seen 23/12/2022. Before the filing of this writ petition, my lord.
But
And
see, page 29 of the writ petition. I mean, the page 30,
yes, my lord.
this executive engineer, signature of the executive engineer.
Signature of.
Then come to page 29 of your affidavit.
Yes.
10%. Hmm?
Yes, ma'am. Payment,
Same person.
same person, ma'am.
Why?
Ma'am,
Why do you have said that payment till the outstanding bill amount? Huh?
yes, yes.
Showing this 12787 so and so.
This
Same
is-
person.
This is outstanding, my lord. This has not been supplied, my lord, till date.
Hmm?
This has not been supplied, my lord.
No, what I'm saying is you have shown that he has given, payment has been this much and outstanding is this much. Same person.
Payment till date, my lord. Payment made till date, my lord, and outstanding. This is, my lord, the outstanding amount which if he supplies, my lord, out of the total contract, my lord.
Okay. And what
In-
about the completion certificate?
Completion
Page
certificate,
29.
we have disputed, my lord. Even in our affidavit, we have stated, my lord, regarding the completion certificate and this also, whether, my lord, we have disputed that this completion certificate is for installation. There were not only one supplier, the petitioner was not the only supplier. There are other suppliers also. Installation was completed.
This is certified so and so, page 29.
Yes,
Has successfully executed and completed the supply of line materials. It is the contractor informed executive supplier so and so item works described in the contract and the details of contract and main works are as under. So and so 100% completed.
here, my lord, we have said that it is only the completion certificate was only with respect for the installation, and because there was.
Has he been awarded with the installation?
No, my lord.
Then
Supply,
page 29
this is supply, my lord, page 29, my lord.
of the writ petition. What is the statement with regard to your this
My lord,
page
this,
29?
my lord, this very certificate has been disputed, my lord. Whether it was issued, whether there is a record of issuance of this certificate, my lord, in
Why
our.
not just discard like that,
My-
disown like that?
My lord, here, my lord, at page
Paragraph
7,
you
my-
have said
Paragraph, yes.
in your affidavit.
No, my lord, in my
petition.
writ petition.
Paragraph 3.
Yes, ma'am.
Just wait. Just let us see. What is it? Issued by the acceptance and issued. What is your statement regarding your reply to the paragraph 3?
my lord will find at page 7. Page 6, my lord.
Page 6.
Subpara A, my lord. 7,
As regard letter of acceptance from the contract agreement and
we have disputed annexure 4, my lord.
with regard to the of the writ petition, I mean, a field inspection report on respect of completion.
Yes.
See,
Field inspector.
this I mean, the response is the real custody and all the revenue according to Sabagi scheme and according to this, no such record of completion as entered in the agreement is available in DBJ. Agenda for any request. No, it's you just
Further, my lord,
evading reply.
further, my
You
lord.
have not
No, my
disputed
lord.
this.
Further, it is to mention that when a certificate letter is so and so, record of issuance of certificate is entered into the DAG dispatcher register of the office. In this case, the completion certificate is dated so and so, whereas the DAG, there is no DAG dispatch also, my lord. And further, the earlier, my lord, at page 9, the earlier incumbent. Furthermore, in this regard, it is necessary to mention that the respondent number 4 herein 4/5/2023 to the present incumbent executive engineer rowing asking further clarification from the EE about the then EE about the completion report and material inspection report. Consequently, the present incumbent executive engineer rowing had written a letter dated so and so in this regard to the then incumbent executive engineer of rowing electrical division, Mr. So and so, who had executed the agreement with the petitioner, Rinya Enterprises, for confirming the veracity of the completion report of the Sorobberg project submitted by the petitioner in the writ, wherein the then incumbent executive engineer clarified that the said completion report cannot be confirmed as genuine and authentic. Therefore, when the then officer is not confirming the authenticity of the completion report, and additionally, when present incumbent officer is not accepting the completion of the work, the department is duty bound to negate the completion. We have disputed, my lord, how this was issued, the very basis. So, my lord, there is a serious dispute, my lord. The completion report on which he is, that is itself disputed, my lord. Now, when disputes are
Yes, it's okay. You go to civil court. My lord,
whether this
heard
honorable
Mr.
court,
D come the learned counsel for the petitioner. And also heard Mr. and the additional advocate general for the
My lord,
state. And Mr. L. Permit, learned standing counsel for the power department. Huh?
my lord,
We're dismissing it.
no, my lord may not dismiss me.
We'll record everything.
Because
With reason will dismiss.
my lord,
Or not just one
because
line.
erection, my lord, erection can only be done after this material is received from the supplier, my lord. Since my lord has seen the inspection report for erection, my lord, how without the supply of this material, my lord, erection be carried out, my lord?
No.
Since they,
Sir, why don't you try to understand? I am not disputing. This court is not disputing that you have not supplied. You may have supplied. You may not have supplied. That this court cannot, while exercising writ jurisdiction, cannot.
that is therefore, my lord, I have placed this judgment, my lord. As per this, my lord has, honorable court has, my lord,
I will. I'll
my lord,
record that.
this is regarding, although writ court has jurisdiction, my lord, to entertain, but roving inquiries, my lord.
No, these are all
Yes, ma'am.
settled position.
yes, my lord.
I am not saying that even if they raise a dispute, just because for the heck of disputing it, will not entertain. But your own showing, relying on the documents which they have clearly disputed,
They,
Author of that completion certificate is also
my lord,
confirming it.
my lord may also observe, my lord, that my lord, after I have filed my affidavit in reply to their affidavit, my lord, annexing this document, my lord, whereby petitioner has able to show that all the material were fully supplied. They have not given answer to that, my lord. They have not filed affidavit disputing this document, my lord. My lord has made a query, my lord, whether this document is obtained through RTI or not, my lord. My lord has said this document has the bearing of the seal and signature of this officer, my lord.
The author who has issued a completion certificate after issuance is
No, my lord,
and
he
it
is
is
not
not an added.
my lord, my kindly,
So-
my lord, my kindly.
So those documents which got its signature, we don't know.
my
No,
lord,
no, I'm not saying that you have not supplied. You established before the jurisdictional civil court.
my lord,
Alright.
that is why, my lord, since
Sir, I'm sorry.
this is,
That's all.
we are under 226, my lord.
Yes.
Yeah, 226, my lord,
Therefore,
may not go into the deep in taking evidence, my lord.
yes.
But my lord, here is a case, my lord, I could able to show
Yes.
from the document that, my lord, I have
You
fully
have,
supplied the material, my
you
lord.
have well,
In such a case, my lord,
sir, you have well, it's okay.
my lord may kindly,
This, by filing this application,
before my lord, dictation, my lord may kindly have a look at page number 28 of their affidavit, my lord. This is their annexure, my lord. That officer, my lord, who has issued the letter, my
we'll
lord,
take it up at 2. We'll continue other cases. I've heard you, Anand, but then I'll take it up at 2.
and my lord, may dispose of the matter.
No,
My lord, may-
2 o'clock. 2 o'clock. Take it up at 2 o'clock.
My lord, may only, if you
Yes.
excuse me, my lord.
Item number 15.
Hmm. Yes. Who appears? Government?
Lordship, is it item 24? I could not hear. I'm very sorry.
Item 15.
Sorry, I'm sorry, Lordship.
Who is this? Petitioner in pursuits. Huh?
Lordship, I'm the counsel for the petitioner, item number 24, Lordship.
Are you a counsel?
Lordship.
Then why you are in this affair? Is it a
Lordship.
black coat? Is it a
Lord-
black coat?
Lordship, I'm waiting for my turn to come. I will be wearing my gown and coat. I'm waiting for my turn to come. I could not hear the number, Lordship.
Yes. 15.
Yes, we have filed our affidavit.
You have filed.
Yes.
Well, dismiss it. Have you seen the judgment of this court? None appears for the petitioner on call. Next para, MS Arbasar, London State Council submits that she has already filed the affidavit.
Yes.
Saying what? That she has encroached
She
the
has
government
encroached,
land.
yes.
There's a judgment. That is that not only encroachment, they are challenging those notifications. I don't know whether this has been taken to appeal or not. I don't know. There's 2 judgments of this court. List after 4 weeks, 3 weeks. You find out
Got it.
they related 2 cases on this notification of requirement of this NOC for enforcement and all.
Please, Your Lordship.
Yes.
Your Lordship, this is a criminal appeal filed under section 374 of.
Yes. What is to be done? Today is for what?
Yes, today it's for
Lordship, delay condone, Your Lordship. Now it's for admission and consideration of IA
Okay,
for suspension of convict or sentence.
Petition has been allowed by this honorable court.
okay. Heard Miss MS so and so learned counsel for the plan and also Mr. T at the London Edison BP. Next para. This is an application, this is an appeal under section 374 within bracket 2 of CRPC 1973. Directed against the judgment and order dated 01/03/2024. And sentence dated 11/03/2020 passed by the Special Judge NDPS. West page 1 and 2 of the appeal. So and so, in NDPS case number so and so, under section so and so. We'll admit this.
Yes,
We'll
Your
admit this.
Yes, Your Lordship.
Admit. Next para. Then what is to be done?
Your
Call
Lordship.
for the trial court record.
Yes, call for trial court record, Your Lordship.
Admit, call for the trial court records. List after 3 weeks.
3 weeks.
4 weeks.
3 weeks.
3 weeks. Then IA for
Suspension of sentence.
will issue notice. In IA also. What is the IA? In the IA. The IA so and so. Application for under section 389.
Yes, Your Lordship.
Are you getting it? In IA, this is an application under section 389, within bracket 1 of CRPC for suspension of sentence during the pendency of the connected criminal appeal against the judgment and order. So and so same, Then issue notice. List along with the criminal petition after 3 weeks.
Obliged, Your Lordship.
I think number 70.
Lordship, this is the 7th time that a fresh notice was to be taken, Your Lordship. However, they have not taken the fresh. There was a direction for taking fresh step, Your Lordship. Thereafter,
Nobody appears.
no, nobody appears.
No one appears for the petitioner on call. MST. Next para. TG not present. It is noticed that dispense several direction for fresh steps. The learned counsel for the petitioner has failed to take steps till date. Who is the learned? Why?
G. Talo was appearing in this matter. G. Talo was appearing in this matter.
Mr. Considering about as a last chance, the learned counsel for the petitioner is directed to take precise steps within 7 days. You just inform who is
Yes.
that.
Item number 18.
Make it first. Finish this. Finish the order. Yes.
Your Lordship, here in this case, Your Lordship, we have come with an affidavit. In fact, it was filed by me only, Your Lordship, as an additional PP. By pointing on the, Your Lordship, distance taken by them, that they try to, Your Lordship, showing the cause of death of the victim. It's basically it's a, Your Lordship, POCSO case. And they are approaching this court for quashing under the jurisdiction of under inherent power of 482. So in the meantime, they have filed affidavit. Will bring into record during the pendency of this application, the victim died. Then the cause of death has been shown to be natural death, Your Lordship. And in the meantime, Your Lordship, we have learned that it was not because of the natural death. In fact, she has died out of unnatural death, Your Lordship, which we bring into the record, which is in the record, Your Lordship. We have filed our affidavit and we have already filed before this honorable court, Your Lordship.
You have the updated case diary,
Your Lordship, it's already charge sheeted.
charge sheeted.
Yes, Your Lordship.
Okay. Updated record in that case? Nothing.
Earlier it was pending. During the pendency, the investigation was completed and charge sheet filed, Your Lordship.
Lordship, may I please?
Yes.
Lordship, this
What is the, why it been listed for orders today?
Because, Your Lordship, is for affidavit from our side. Yes.
Okay. Affidavit has been filed. We'll fix it for admission. All right. And Mr. T. Thorum, learned consent for the petition. And Mr. T. at the learned additional PP. Submitted. Yes. File the affidavit.
Your Lordship,
with this court.
this affidavit, Your Lordship,
This
may I, Your Lordship, this matter was already admitted, Your Lordship. This actually, in the meantime, they have filed an additional, bring into record the date. Cause
Okay, the list for admission after a week.
Okay, Your Lordship. Obliged.
Item number 19.
Your Honor, today it's for.
No steps.
Your Honor, in the.
Mr. So-and-so learned counsel for the, you are for petitioner.
Petitioner, Your Honor.
Learned counsel for the petitioner. The learned counsel of petitioner is directed to take steps within 2 days from today.
Obliging. And interim order may be continued.
Interim order process will continue.
Obliging.
Item number 20.
My lord, this is an application for quashing of the criminal proceeding against the accused person.
Why this has been listed today?
Your Honor, my lord.
On your prayer.
My prayer is, my lord, quashing of the criminal proceeding against the accused person.
No, why this has been listed today?
Today, my lord, order dated 23 February 2024. On the direction of this honorable court, the other persons, Your Honor, that is petitioner number 1 and number 2 were present, Your Honor, and interacted with them. And they have admitted that they had executed the settlement deed.
Okay.
And today, my lord, it is in last paragraph, it is written that the learned counsel for the parties on the next date shall make their submission to whether this court is exercise its power under section 482 CRPC and quash the proceeding wherein the charge under section 304A IPC is also involved. So today, my lord, I have my submission is, my lord, I have one case citation of Guwahati High Court GLT 22 of 5136. Party's name is Rajan Hankar versus State of Arunachal Pradesh, my lord. In this case, also similar question was, Your Honor, arise, Your Honor, and
Okay.
it was.
But Mr. J. Doji, learned counsel for the petitioner, and also theater learned addition people for the state. Will list next week for admission so that it can be disposed of. Right?
Yes, my lord, case is, criminal case is, proceeding is under process, my lord, is going on in the Pasigat.
Okay, next week, in that case, next week. All right.
My lord, proceeding may be, my lord. Since, my lord, accused person is a student, my lord, so.
Next week.
Yes.
No, record.
Next week.
Record is received.
Records
Original scan copy.
The photocopy perhaps.
304A.
304A.
List the matter for admission after 2 weeks. In the meantime, the proceedings of GR case number. Huh?
Yes.
You just give the GR case number so and shall remain.
GR case number 47 of 2022.
2022 under section so and so. Pending before the
Learned CGM Pasigat.
CGM.
Yes.
Yes, Your Lordship. It's punishment is up to perhaps 3 years.
CGM, spending
Yes,
before the
yes.
CGM.
Yes.
304.
Yes, your lordship.
Okay.
This
CGM
is
plus years.
negligence.
Shall
That's
remain
a
state.
negligence.
Shall remain state. Yes, next.
Obliged, your lordship.
Yes, sir.
Service.
Award service reports. List after
3 weeks.
3 weeks. You just write like that. Award service reports for another 3 weeks. Huh? List after 3 weeks. Same. Yes. And Kera. 23 and 24.
22 and 23, your lordship.
Huh?
22 and 23, your lordship.
Same.
Same. I'm speaking on behalf of.
Yes, yes. Okay, that's all we do. This is 23. Huh?
Yes.
Yes. What is to be done here? Heard MSO and social council. It is noticed. What is it? Last time you didn't appear. Yes, scan copy of the trial court record is received. List for admission after 2 weeks.
There is an interim, lordship.
Interim order shall continue.
In item number 22 and 23 both. Lordship.
Interim order continue, huh?
Much open.
Item 24.
Good afternoon, Lordship.
Yes.
Lordship, this is an appeal we have filed, Lordship, against the judgment and order dated 6/12/2023. Lordship, passed by the Special Judge Pokso Khonsa Division, Tirap District, Arunachal Pradesh. There is a delay of 195 days, Lordship, for which we
We'll
have
issue
filed.
notice. We'll issue notice. Heard Mr. So and so. Nitin Kera.
Lordship.
Learned counsel for the petition applicant. Next para. This is an application under Section 5 of the Limitation Act 1963. For condemnation of delay of 195 days. 195
195, Lordship.
in filing the connected appeal against the judgment and order that is 06/12/2023 passed by the Special Judge Pokso Khonsa Division, Tirap District in KSA/SA within bracket Pokso case number 04 of 2022. Against the acquittal.
Lordship. Against the acquittal.
Against the acquittal.
I am the mother of the victim,
For
Lordship.
an offense under Section 354A IPC read with Section Pokso Act 2012. Issue notice, returnable of 4 weeks.
Highly obliged, Lordship.
Any respondents?
Your Lordship, yes, Your Lordship, I'm just with regard to the respondent, Your Lordship. There are so many respondents which are not absolutely necessary. However, the state is made party represent through the secretary home. It ought to have to be.
We'll see next test. Private respondent is there, accused is there.
Accused is
Absolutely, Lordship. Accused is there.
Mr. So and so, the learned counsel for the petitioner shall take steps for service of notice upon the respondents. Whatever.
All the respondents, Lordship.
All the respondents. List after 3 weeks. Huh?
Lordship, it will be after 4 weeks, Lordship, because there are Assam Rifle is also respondent
So make
based
it
in
fi-
different
So make it 5 weeks.
Lordship.
5 weeks.
Lordship. Highly
Yes.
obliged, Lordship.
There also, your lordship, I beg to mention.
Yes.
After 2 weeks,
What?
matter may be less after 2 weeks.
What is the last order? I deem it approved to consider several next according the objection raised by the petition. What is this?
Lordship,
Any objection?
Lordship, on last occasion, Lordship,
After consideration-
additional PP objecting regarding the participation, Lordship. There were there should be 3 petitioner, but only 2 participated, Lordship. That was the objection, Lordship.
Yes. There are 3 accused.
Okay.
Only 2 have filed.
Yes, sir.
The yes.
But I mean, he may be made party, Lordship, by filing.
Who is appearing? Are you?
Yes.
Are you aware of the case?
Oh, your lordship,
Then-
I'm not aware of the law.
Why you are appearing?
I have only
You
directed.
don't know anything.
Who
Who is your senior? Who is your senior?
Itaba.
List the matter after a week so as to enable the learned counsel MSc hearing. Hearing
And only.
and Hondi to take instruction from his senior Mr. Tikaba on the issue.
Hearing is appearing, Lordship, here. Hearing is appearing. Lordship.
Whoever Tikaba or say.
Oh, Lordship. Okay.
Lordship, I am for the petitioner. My lord,
Yes.
I'm newly implemented, my lord, respondent number 3, my lord.
Who has implemented? You implemented
Yeah, yes.
yourself. Who has implemented?
Yes, I am, my lord.
You yourself.
Yes, so I may be given some more time to file an affidavit, my lord.
Mr. Heard Mr. N. Regum
Arnabam.
or Arnabam.
Yes.
You have changed your name.
It's officially Arnabam.
Huh?
Arnabam, Regamnabam, officially.
Arnabam, Regum Nabam, learned counsel for the petitioner. And also MS L. Hage, learned additional PP for the state. Mr. Odugong, learned counsel for the
Respondent number 3, my lord. Victim, my
respondent
lord.
number 3. Respondent is granted 3 weeks time to file
Affidavit, my lord.
affidavit. File
Counter.
affidavit.
Much obliged.
Yes, we'll continue at 2. We'll continue at 2. Any other agreement
Yes, my lord.
or disagreement?
To my humble understanding, my lord, since they have not disputed this document, although I have annexed my rejoinder, they have not said anything that this document is
There cannot be
effective
a-
now. So
There
therefore,
there cannot be a replication.
therefore, my lord, in terms of the judgment, as I have supplied the judgment rendered by apex court, that is clearly cover my case because for the sake of dispute, they are disputing. My lord can see there is a inspection report, my lord. They are not disputing that the inspection report was not carried out. There is a completion certificate, my lord.
Who were there? Earlier in this case, who were there? Huh? Huh? Tell Kola, you go.
Since, my lords, there was a field inspection report, this issuance of completion certificate, then demand for the fund for,
They are disputing the completion certificate itself.
my lord, they have even demand for the fund to be released for payment of the work executed by the petitioner, my lord. My lord has seen that document also. There they have saying that and on receipt of the demand letter, my lord, my lord, I'll just.
That's all. I'm not convinced. It's purely disputed question of facts. They have disputed. Had it been some other issue, simply only what we have.
Now, my
Our
lord,
jurisdiction is limited.
this to my humble
I'm
understanding, my
not
lord,
saying that
there is-
there is a. I mean, it depends on case to case.
That is why, my lord, in my case, my lord, my submission is that there is no dispute at all. They are disputing for the sake of dispute, my lord. I have annexed all those documents, my lord. They have not said that, my lord, this document is a false one, fake one. Since they are not that this document is fake, then that is admission, my lord. If this document is admitted, my lord, there is no disputed text, my lord. Therefore, this judgment, my lord, rendered by Apex Court is going to
Sir,
cover
I've
my case,
heard
my
you
lord.
for 1 hour, not convinced.
My lord, it's of course.
What is to be done?
Then, my lord, I obviously pray that, my lord, let me try my luck in some other place, my lord.
That is the third Mr. Sir and learn concept. You come to learn the concept for the petition. And N written and L permit for learn concept. Next paragraph. Mr. D come to learn consent for the petitioner. After arguing the matter at some length, press that matter some further time may be given so as to enable enable him to make a submission, make a further submission on the maintainability of this writ petition. Mr. Prayer not being objected to by learned counsel for the respondents. Let the matter be listed below. Any other appropriate bench?
Yes, my lord.
That you cannot, we cannot. Let this matter be listed after 2 weeks.
My lord, much obliged.
We'll come back. Will come back to me. We'll come back to this court.
It's okay. I'll be better prepared, my lord. I believe I'll be able to convince
2
you.
weeks, I think. After 2 weeks means you may
My lord.
pray that it doesn't come back again. I'm not convinced. Best of luck. You have.
At least I have 2 more weeks, my lord, so that I can.
You fought well.
Much obliged.
Always.
My lord, will interfere with that
Yes.
deputy commissioner's order, since he do not have the power. And then let the ADC order will be surviving in his favor with a small liberty to the petitioner or the parties to approach appropriate forum.
In accordance with law, my lord.
That's in accordance with law. That's nothing big, my lord.
Heard Mr. Tititara, learned counsel for the petitioner, and also heard Mr. L. Nosi, learned counsel for the respondent. Only one respondent.
Yes, all respondents.
What is the impugn order?
It's in my lord, page 58, my lord. Another 12.
Next paragraph. Telling this revision petition the petitioner has assailed the order dated 05/10/2017 passed by the Deputy Commissioner, West Shell District. Where it is, page 58.
58, my lord. Yes, fairly admitted, my lord. Even page 59. Even though as per LA Act, no jurisdiction lies with Deputy Commissioner against appeals from land settlement officer. As per direction of the Honorable Court, the case was heard.
Okay.
Yes,
There was a direction from this court to the. Where is that direction? No, continue. Where the Deputy Commissioner, you find out that has upheld the decision of the ADC, within bracket Kamba, dated 28/05/2014, wherein where is this ADC's decision?
It's in page 30, annexure 6.
30.
27/12/2013.
Page 30.
Page 30.
Yes.
Type copy is in 33, madam.
33. The ADC Kamba, huh?
Correct.
So and so. Relying on the, based on the Kamba decision, that is 1990 and 1990, wherein petition respondent, wherein the decision was in favor of the respondent. The compensation amount was to be paid to the respondent. Listen. Next paragraph. Sort of unnecessary facts. The disputes relates to a plot of land at Kibo Digo area. Listo. Kibo Digo area at Kamba. The land in question according to the petitioner, which was given to the petitioner in terms of the Keba dated 10/12/1987, which has been duly approved by the circle officer on 08/01/1988. It is contended that in the year 2012, while ADC Kamba was carrying out a survey for compensation to the affected landowners, but the respondent has raised in dispute that total area measuring approximately 177 square feet belongs to him in terms as per the Keba dated 02/09/1990. Due to such dispute, a Keba was conducted. There is no Keba.
No Kaba was there.
Okay. The list of due to such claim by the respondent, the petitioner made a complaint to the ADC Kamba.
Correct.
As the very ADC Kamba list of the issue relates to the title and the ownership of the same plot of area. At Kigo Dego area, where both the parties appears to have both the parties claim on the basis of both the Keba dated 10/12/1987 and 02/09/1990. On the complaint of the petitioner, the ADC has passed, after hearing the parties and the village authorities, has passed the order dated 27/12/2013. Against the petitioner. Against the petition on the basis of the Keba dated 0/09/1990, which is in favor of the respondent. Next paragraph. On the perusal of the Keba, the order of ADC Kamba dated 27/12/2013. The ADC has relied on the AGC has declared on the Keba decision 02/209/1990, and on that basis, it has been decided that the compensation since the respondent is the owner of the land, the compensation was decided to be paid to the respondent. Next paragraph. Against the 27/12/2013 passed by the ADC Kamba, the petitioner, was that appeal? The petitioner has filed an appeal, huh? Page 30. Before the Deputy Commissioner, West Siang District. Lister. The Deputy Commissioner, by the impugn order dated so and so, impugn order. Page 58, no, 52. Impugn order is page 58, my lord. 58, huh? Dated so and so, that is so and so. Has upheld the decision of the ADC Kamba and dismissed the appeal. Hence this present petition. Will not go into the merit, who is what. On consideration of the, no, not consider. Perusal of the records, perusal of the materials on record, including the order of the order dated 27/12/2013 passed by the ADC Kamba and the impugn order dated so and so passed by Kamba goes to show that the petitioner has wrongly approached the Deputy Commissioner as under the relevant provision. The appeal against there would not be any appeal against the appeal before the Deputy Commissioner against the order of decision of the ADC, Additional Deputy Commissioner. Please stop. It is also reflected that the decision of the ADC Kamba strictly cannot be termed to be a decision with regard to the title and ownership of the land, but a decision based Keba decision, and thereafter the compensation was awarded to the respondent as in his view the Keba has decided the land, the Keba already decided that the land belongs to the respondent. Please stop. It is also noticed that the compensation. It is also noticed that there is no proceedings for land acquisition strictly under the right to fair compensation. Is it? Was it under 2013?
No, my lord, it was under Hume land regulation, my lord.
Was that strictly in terms of the 2013? Right to fair compensation, so and so, huh? You find out. However, since the petitioner has filed an appeal before the wrong forum, I'm of the view that the decision or the order is a nullity, as the deputy commissioner has passed the order without any jurisdiction. Please stop. Next paper. At this stage, the learned counsel for the parties fairly submits that the petitioner has wrongly approached the deputy commissioner, wrongly approached the deputy commissioner contrary to the provisions, in violation of the provisions of law, the order impugned in this petition that it's so and so passed by the deputy commissioner is a nullity, as the deputy commissioner would not have any jurisdiction. The parties also have consented and submitted that since the order of the learned deputy commissioner is nullity, the parties may be relegated to appropriate forum. So that the determination can be made by the jurisdictional authority or court in accordance with law. Next paragraph. Having considered the submissions of the learned counsel to the parties, and also considering that the deputy commissioner has no jurisdiction, has no appeal lies against the order of the additional deputy commissioner under the law, without going into the merit, I'm of the view that revision petition can be closed and disposed of by holding that the impugned order so and so, that it's so and so passed by the deputy commissioner is nullity under the law. List of. Accordingly, the present petition is disposed of. That's all. We declare it null, it's a nullity. Please, next one. However, the petitioner is at liberty to approach the appropriate jurisdictional court against the order of the NC Kamba as may be permissible under the law. I'll fine tune it. There are certain things I may add and delete.